claims administration, book build, collateral review for funders, and been doing this a long time.
Thanks, Steve. David?
Yeah, I'm David Isaac. I'm the Executive Managing Director of J&D Legal Administration. We do soup to nuts, everything to do with settlement administration of class actions and other types of similar cases. And I've been doing this even longer than he has.
Amazing. And so?
Hi, I'm Sare Brownhill. I am a qualified lawyer, but I now work for a tech company who provides solutions for either administrators or direct law firms to allow them essentially to run mass claims, volume litigation with automation and ease, essentially.
Fantastic. And Chris Ford from Blackhawk. So we are responsible for some distributions on a global scale that are directly related to legal settlement. So majority out of the US, but many building in the UK and European markets. So when I think about then the function and the role of class action administration in class actions and collective redress, well, I would be really interested to understand what you think the administrator's key role is. So, Steve, if I could come to you first, just for your thoughts on that.
Primarily to take a US-based analogy to call balls and strikes, but to call balls and strikes for classes that might involve tens of thousands, hundreds of thousands, millions, or tens, or in some cases, hundreds of millions of people. So you have to have the ability to both clearly and cogently communicate those people's rights to them, and then when they try to exercise those rights, to have the impartiality to both, on the one hand, make sure that they get to be meaningfully heard, on the other hand, make sure that you're not letting people claim money that they aren't legally entitled to. So it's really, in some ways, a ministerial function, but in some ways, it's also the front lines of a PR effort on behalf of a company that might be settling litigation in order to move on, and they don't want their customers or their investors or their employees being provided with information that's anything less than factual at a minimum. So it's really to handle communications and adjudication of hundreds of millions of claims on an annual basis.
Yeah, so that connection, the glue almost between the case and the consumer is part of that function of the administrator, particularly in terms of the data, the validity of the data and so forth. David, what's your views on that?
Yeah, very similar to what Steve just said, but I would add that, and I haven't heard too much about that so far today, is that we're always beholden to the court. We all want to do what's right. We all want to try and help the consumer or the investor. But our Bible is the settlement agreement, and we are bound by that agreement. And at the end of the day, we have a judge to report to. And I think that's one of our guiding principles, is making sure that when we get to that final day, the final approval hearing, and when we get to what's now become, we heard this mentioned before, I think by Jeremy, about the Northern District of California, you have responsibilities now to report to the court after the case is completed, that we've done everything that we were supposed to do, and that it's been handled according to everything that's in the settlement agreement. And that's, for us, to use Steve's analogy, the ultimate umpire for calling those balls and strikes is the judge, and that's where we have to be most focused.
Okay. And Sam?
Sure. Well, I probably work slightly more with the opt-in sort of regime rather than the opt-out, and obviously in that sense, there's a significant headache to book building, whether that be 50 people or 150,000, and that's incredibly difficult. So I think any form of automation, dare I say the word AI, which hasn't quite been sort of, spoken about as, today yet, all of those things are coming our way, that unless you have an army of people to service those clients, you need a kind of a robust system in which to do that. So I think we have a bit of my role is much more of a function with the opt-in side rather than opt-out, for that very reason, because we have to collect the same levels of data, all the validity. The fraud is a massive, massive thing. We're doing quite a lot of work in the US, where obviously, as we've heard today, everything about sort of, adverse costs and that being a problem if there is, fraudulent or frivolous claim made. So how do you stop that from happening? So kind of that's part of my role and the way we approach it.
Yeah, great. And I think seeing the fact that there is 9 administrators that attend this conference, and more probably will attend this conference, the importance of that administration function to make absolutely certain that the case is solid, that the data is checked and valid, that the process through to the court, David, which is a very good point about you're acting on behalf of a judgment, which means it has to be robust and solid, to ultimately making a payment to the end consumer. The function and role of the administrator in the ecosystem of collective redress, I think, is a pretty pivotal part of making certain that the process from start to finish works effectively. I'll almost say as pivotal as the funding in the first place that we've just listened to. Because although somebody is willing to fund a litigation process, unless it's really robust in the data, the fraud aspects, and the quality of its delivery, the thing that will always unravel is that the end consumer doesn't receive the damages because there's holes in the process. So the effectiveness of the administrators certainly shouldn't be underestimated.
Can I just speak to that
Of
for a
course.
minute? Because I think it's interesting, and I'll bet you most of the room does not know the history of where notice expertise and claims administration really came from in the U.S. system. As a lot of you know, class action litigation can be protracted. It can go on for years. It's adversarial. Plaintiffs' counsel and defense counsel are fighting the good fight for 3, 4, 5 years, and then they would reach a settlement. And now the process is fairly non-adversarial. Everyone wants to move on. Everyone wants to get a release for their client on the one hand, get paid on the other hand, and they were incentivized to get from that point, from the point where the case is settled to the point where everyone gets what they wanted as quickly and as seamlessly as possible, which is great in theory, except that class action litigation is unique in that people are being bound, the class, whether or not they've heard anything about this class action, they've had the opportunity to exercise their due process rights. And after a certain amount of time of the attorneys kind of getting together and saying, don't worry, Your Honor, we've told everyone about this class action. I don't know why it's a low claims rate or what have you. Judges started appointing independent neutrals to verify the veracity of that the claims process and the notification process was done the right way. And this is, I think, a little bit more well known in the U.S. market because we lived it, but in a lot of the more emerging markets that you all practice in, it seems like, oh, well, I guess we just need them to talk to a lot of people, which is true. But there is sort of an independent doctrinal reason for notice expertise and claims administration, and it's to give the judge the confidence to bind an otherwise absent class, that it's been done the right way. We don't have an interest in the outcome of the litigation. We're an objective third-party neutral, ultimately, like David said, responsible to the court. And I just think it's good to frame it that way because I think it's been my experience that somehow we get pigeonholed as just necessary vendors because you gotta send checks out or digital distribution and or emails. But there's more to it than just the services we provide. There's a philosophical reason for the existence of claims administration within the class action rubric.
Thanks, Steve. We talked a bit about the differences between the US and UK European regimes, and obviously Steve and David have significant experiences in the US, and Sare has experiences both in the UK and in the European landscape. So having looked at it from a distance or being right in the middle of it, what do you see as these major differences that are appearing when it comes to the administration of cases in the UK and European regions? So,
I think there are nuances to both. I think that they have their similarities. I think in obviously anything outside the CAT in the UK is going to be opt-in, which is probably the major difference. Obviously it's a significant difference really, but has a lot of the same issues and headaches. And we are seeing obviously in Europe that there is a little bit more movement towards regimes coming in that are going to probably mirror some of the way we run cases in the UK, and I hope that is the case, because I do think, for all the fact that it's taken years and years to get something through to settlement through the CAT, it is a great regime. I personally don't have a huge experience in the US, so I will let these guys obviously speak about that. But obviously, from a UK, I mean, when I was in practice, most of my cases were obviously issued in the UK. Some of them in the Netherlands, just on the consumer cases. But yeah, that's kind of how I see it.
Look, obviously, the most significant difference is the opt-in, opt-out differential. We don't have to worry on our side of the ocean about getting people to participate. They're already in. So that changes the entirety of the messaging that we have to do. One of the things I'm getting a sense I'm hearing from people today is that there's this notion of reaching out, talking to consumers, letting them know about the redress and potential. It's a little bit different on our side of the aisle, because we are, again, as I said before, bound by certain rules. Even what we can say to class members on the phone or even email is negotiated. So I don't know about how much less adversarial stuff you've been dealing with, but I don't know. I'm dealing with adversarial stuff all the time. And even just negotiating what to say on the phone becomes a fight. And once it's been crystallized as to what we can say, that's all we can say. And it's not, sometimes I get the sense that we should be more like a company's marketing arm, but we're not. There's a limit to what we can say. And if we go beyond that, or don't do what we're supposed to do, one side or the other is going to be upset with what we've done, which is why it's, maybe to get a term that's more global, we need to be down the middle of the fairway. I get the sense that that's a big difference between what we currently have, what's developed over time, and what is developing over here.
Yeah.
I think the main difference that no one has really hit on, and I will say, we do a tremendous amount of work in the U.S., obviously, but we're the notice administrator on about a dozen cases in the CAT. We're working in the Netherlands. We're working in Argentina. We have lots of international experience, different jurisdictions. But to me, the biggest difference that I found, well, there's two, but for the administration specifically, is sort of procedural and pragmatic. In the UK, the administrator is typically retained at the time of filing by the claimant's law firm, right? And you have a duty under the tribunal rules to publicize the actual filing. So we're being retained and entering the notice and administration plan as part of the initial filing with the tribunal, which doesn't exactly smack of neutrality, right? Which is what I came up here, and David just said right down the fairway. And I'll tell a personal story about this. We've done for many reasons a tremendous amount of work in data privacy and data security, working with the largest platforms in the world. And we did a settlement in the U.S. involving one of these large consumer electronics companies, and I got a call one day from a claimant's firm who wanted to retain us to be the administrator on their case. And I was very concerned that was going to be perceived by a good client of ours as us being less than neutral if we're going to have my declaration attached to their filing. So I called them and I was like, I obviously didn't disclose what the lawsuit was, but I did say we've been approached about a lawsuit. It's in the UK. I don't know how much you know about the administrative rules around the CAT. And they're like, well, we'd rather it be you than anyone else. Go ahead and file it. But, and do that. But I don't know that all clients who are used to the administrator being right down the middle are going to be comfortable with their administrator being on a filing in the CAT at the UK. And that does cause me a little heartburn, because at the end of the day, you're still being neutral. You're just being attached to a claimant firm filing, and that in and of itself does have the potential to at least appear less than neutral.
And I think that the comment that David made about opt-in and opt-out, and most of the work has been on opt-out, where you have a claimant base that you are in the claim already. What we've seen in some of the stages of the cases from a UK point of view, where they're opt-in, that mechanism of communicating to the class to establish credibility, trust, reliability, and that consumers want to be part of the case. One, they find out about it, and then secondly, they're prepared to give their information and details, is becoming more and more part of the administration process. So it's an interesting evolution of, if I think about the traditional role of the administrator versus how that is evolving, it becomes even more important that not only are they great with data management, data processing, fraud management, and so forth, but they also can reach people across multiple channels in a mechanism that's impactful to the recipient. So that produces a difference between what's traditionally been the US approach versus what could be seen more in the UK and European markets. Obviously, some of those cases in the UK and Europe will become or are already in an opt-out regime. I'm always very interested to understand the measures of success. So for me, I'm not a lawyer. I am very interested in this space. But for me, looking at this market, I want to receive damage payments when business do wrong as a consumer. And I often go through the process of thinking, what are these measures of success? So in this regime, whether it's the RAD or the CAT or in the US, from an administrator's point of view, what do they see as measuring success in a case? David, if I could come to you.
Well, that's easy if I get hired again by the same company.
Excellent.
For us, and we've been using sports analogies over here on this side of the dais. For us as a company, there probably are, the biggest measure of success for me is I want to be the offensive lineman in a football team, an American football game. I don't want to have my name called. I don't want anybody to know we're even working on the case. It means that we did a smooth job. Nobody called our name, no penalties, no issues, and the case gets done smoothly and everybody gets paid. Ultimately, the key measure to success is if we have a settlement fund, we need to be sure that the dollars have all been spent in terms of properly spent and divided up to the claimants who have been approved by the court. That's ultimately the goal. If there's too much money left over, there's something wrong. May not be our issue, but there may be an issue with the case, with the data. There could be issues, but at the end of the day, that is our job, and making sure that the settlement fund has been properly allocated to where it needs to go.
Thanks, David. Sarah.
Absolutely. We're all here on the claimant side, if you sit on that side of this table, to get consumers, claimants, plaintiffs, the money that they deserve because of wrongdoing. So the absolute measure of success is that damages are rewarded to people who are deserving of those damages, and that it gets paid out, hopefully in a timely fashion and not decades later, but in any event that it gets paid to them. And that is the measure of the best measure of success.
Right. Steve, anything to add to that?
Yeah, I would say that it actually is finality is the measure of success. When there is an order approving of the work that was done by all parties and everyone can move on and put the case behind them, I think that's the ultimate measure of success. Mm-hmm. Obviously, all of the issues that were raised by my co-panelists are important, but at the end of the day, we are beholden to the judge or the justice overseeing the case, and they're going to put all of those issues and more into an analysis, whether or not this was fair, reasonable, adequate, executed properly, yada, yada, yada. If we get through that and the judge signs the order or bangs the gavel and we have a final approval order or its corollary in a different jurisdiction, to me, that's success.
Excellent, thanks. Just moving on to things like we spent some time actually at last year's conference talking about the blueprint to trial and what that looks like. There has been, since then, lots of discussion about disbursement planning because we're reaching the stage when disbursements are going to start to happen across the UK and European regions. And we've talked in the past about the blueprint to payments. From an administrator's point of view, how much do you get involved in the disbursement planning piece of that? So goes through court, some form of process happens, you now have an opportunity to plan the disbursement. What's your involvement been in that, and how have you felt your activities in that space? Sarah, anything? Nothing?
Well, I suppose slightly different, but I suppose some similarities. That's the whole point of kind of the platform that we've created, is that it will allow either law firms directly or administrators as well to plan the cases, to be able to plan full disbursements, and be able to do that with relative ease, really, so that at every stage everybody knows exactly where that case is. And I mean the case globally, not just individual sort of plaintiff and claimants. And being able to, we are getting to the stage where settlements hopefully are going to be coming in the UK in the distribution of funds, and that's obviously going to be a really important step. And it's about having a great sort of payment provider, making sure that funds are distributed quickly with all the regulatory parts of the SRA that we have to obviously consider in the UK. And obviously we've built it to be able to do all of that and do that with ease, because I think it's going to, there is the potential for it to become very, very messy if that's not there. And we'll be back in sort of early 90s, where people have got a great big sort of Excel spreadsheet otherwise, where they're trying to distribute funds and things like that, which will be hideous.
And do you feel you get involved in that disbursement planning early enough or not?
Yeah, I would say we try to get involved, especially on the opt-in stuff, as soon as possible from day one, really.
Right.
Yeah.
David?
We're definitely involved in that discussion, certainly. Sometimes we can have significant input on that. Obviously, in today's world, there's numerous ways that money can be distributed to class members. The old-fashioned check way, direct deposit into accounts, electronic means. There's an evolution going on in that world as well, which is actually very exciting and I think very helpful. But in many of the cases that we've been involved in, that whole notion of which way to disperse funds, it's been a negotiated term. And when it gets to us, there's not much we can do. I have one particular client, an old guard insurance carrier. We're on case number 11, I think, with them, and they refuse to do anything but by check. Even though we've told them, look at some other options, they refuse. It's just the way they are. That's their DNA, and we're not going to be able to have any input. So we can advise, we can cajole even a little bit, but at the end of the day, that's going to be the decision, and it's a negotiated term with the parties. But certainly, we have the ability to have input on how that disbursement is going to happen.
Yeah. And Steve?
I think that we have a large ability to consult with the attorneys on what is the most appropriate method or methods to distribute. And ultimately, David's correct in that what it says in the settlement agreement is what you're going to use, but we have a really consultative relationship with many of our clients who, when they're going to a mediation or a settlement conference, they're going to reach out, and there's a lot of things that an administrator can do to help guide that decision. One is by doing a demographic analysis of the class. If we know it skews older, one method might make more sense. If it skews younger, or if it skews underbanked, which is something we really need to consider, people who don't have access to traditional banking products. How do you get money in those people's hands? And that's one set of factors that we talk about. The other set of factors that becomes extremely important is when you're reporting back to the judge, if you go with some traditional methods, there's a second or third step that have to be taken. You have to go negotiate a check, for instance, go to a bank, whereas if we're using certain digital distribution options versus other digital distribution options, you're literally pushing the money directly into their account or directly onto a prepaid card, and that allows the attorneys, when they're reporting back either at their post-distribution stage, to say we've distributed this percentage of money and not this percentage of money, because you might send a check that never gets cashed. that doesn't count. That doesn't make them look good in front of the judge. So there are certainly a lot of different factors that you need to consider and consult upon, but ultimately it is the attorney's decision on how they want to distribute the funds in their settlement.
And I think there's even a hybrid which is developing now, and actually I think we're working, Chris, with your company on this, where at the front end of the case, it was done by check. Technology has changed, things have changed in the world, and now the client is willing to be open to the idea of maybe this next round of distribution should be done in a different method. And that's where we come in, and so it's even midstream of the case, you might see a change and where we can have input on how to get it done. Again, it's their decision, but like Steve said, our role is definitely consultative in that regard.
And I think we, certainly my experience quite recently has been thinking about distribution, obviously the earlier the better, but being in a position to actually influence some of those decisions. And David, you're quite right, it's sometimes based on an inefficiency that they've tried. So, a check delivery mechanism that delivered 5-6% of the claimants receiving a value isn't considered good enough when you're looking at various people across the industry talking about 50, 60, 70, even 80% of funds being distributed efficiently to the whole claim base. So being involved early in a specialist area of disbursement planning, at whatever type of payment process it is really valuable. But it also comes down to silly things that I think most of us take for granted. In the UK, if you collect a mobile phone number, if you're doing that across Europe and you don't identify the country, you won't be able to phone that number because the number has a country code with it. And there are many European countries that all have different country codes as they are across the globe. So if you're collecting data in the first place, where a mobile phone number is valuable for two-factor authentication in making a digital payment, and you haven't collected the phone number because you literally just didn't put a flag on the form that said, is it the UK or Portugal or the Netherlands, etc., that can create real pain at the back end. The other thing that becomes painful is the collection of things like personal banking data. If you haven't built trust in the case, and at some point you ask a claimant for their personal banking data, you're probably going to find claimants are going to drop out because they don't trust the case. They don't feel it's right. If that happens, there is a range of other options that you can use, obviously, to get money into the hands of individuals. But then you have to think about how are you presenting a bank account number and a sort code? Because it's presented completely differently in different parts of the US and the UK when you're filling a form in. So there's tiny little pieces that can really make a big difference at the back end, which is the distribution of the damages to the consumers. So administrators, payment vendors, paywall providers, a whole heap of ecosystem is around this market to try and support it. And I think in every case, everybody would be asking for the earliest possible access to offer advice on what does and doesn't work. I've got to distribute £20. Is that most efficient on a check? Probably not. If I've got to get £20 into the hands of a consumer, but I'm doing it 3 million times, how can I do that efficiently and effectively? And many people in the industry probably won't know the answer to that. If I'm now going to do that in the European regions in euros, again, people won't know the answer to that. That's where you come to administrators, payment providers, professionals that really do understand what makes most sense. And the earlier we get into that, the easier the output will be, and ultimately the more damages will get distributed because people stay in the case. So I'm, from a view of this market, and we're going to finish quite quickly because everybody's waiting for their lunch. If you looked at the UK and European regions, and you looked at things that were interesting, maybe they're things that started in the US and now developing in the UK and Europe, but it could be things that are happening here that you're not seeing as much of in the US. So Steve, is there any particular areas, environments, things that are interesting from an Angeion point of view at the moment?
So I think that the new level of scrutiny we're having around class reps, particularly in the CAT, the cross-examination that recently happened into the funding, is indicative of more serious scrutiny coming from the judiciary around other parts of the litigation ecosystem and not just the litigation itself. And I find that interesting primarily because it will keep the more reputable administrators and other vendors where they should be, and will sort of weed out those who are just, trying to toss their hat into the ring. We always welcome scrutiny. Sunshine's the best disinfectant, et cetera. So I'm pleased to see it. I'm not going to comment on that particular case and how it kind of came out of nowhere and no one had ever done that before and no one could prep for it, all that sort of stuff. But the idea of having more scrutiny around vendors, I think, is a good thing.
Yeah, great. Sarah, anything to add?
I think the UK market, and I think the previous panel touched on this, I think everything that's surrounding sort of consumer protection, the Consumer Credit Act, there's absolutely loads that's going to come out of sort of some recent decisions, some recent Court of Appeal decisions that I think will have a rumbling effect for a long time, which I don't think is any bad thing. Consumers have, especially in the UK, been treated pretty poorly. But I think it's been a market that funders especially have been incredibly nervous about getting into because there were some pretty dodgy players at some stages, but that has been cleaned up and it's looking like it's going to, and there'll be millions and millions of consumers in the UK that will benefit from sort of law firms taking those cases forward. I think it's going to be a very interesting few years from sort of a consumer point of view.
So the automotive industry is likely to get even more bashing.
Absolutely. Well, that looks like it might be somewhere between 18 and 20 million people affected. So we will wait with bated breath to see what the regulator says next year.
David, anything that you've seen from being here or hearing what's been going on?
Well, I think that we're all here is a sign that there's interesting stuff happening, right?
Yeah.
I think that it's worth seeing it evolve from scratch, and the things that are going to be different is exciting to watch from afar. And we'll see, how it continues to evolve, and what parts, will move across the pond, so to speak. I think that's something also that's particularly interesting for me.
Fantastic. So, have we got any questions at all anybody wants to raise at this stage? No? All waiting for lunch? Fantastic. So, just to finish our session a little early so that we can grab our food. I think fantastic panel, lots of insight, great experience. Administrators play a key role in this process, and the success of the regime doesn't exist unless all of the facets of the ecosystem work closely together. So I'm delighted to be having this conversation about the representation of administrators in general, and from the three guys on the stage who have deep expertise in this space. So a round of applause for the panel. Thanks very much for listening.